Hey there, I'm estate planning attorney Paul Rabalais, and in this video, we're going to talk about who you should designate as the trustee of a trust that you leave for your spouse. Okay, so in a recent video, I explained the difference between leaving your estate outright in full ownership with no restrictions for your spouse versus leaving your estate in a trust for your spouse. But many people like the dual objectives of leaving their estate in trust for their spouse because they accomplish two things. One, they accomplish providing resources available that their spouse can live off of for the remainder of their spouse's lifetime after they pass away. And they can accomplish the goal of controlling where those assets go, not only when you pass away, but when your surviving spouse passes away as well. So many people like that dual objective of leaving their estate in trust for their spouse. But when you set up a trust, you need to name a trustee, and the trustee needs to have a good understanding of the legal and financial concepts that are involved in being the trustee. So in this video, we're going to discuss who you should name as the trustee of that trust that you set up for your spouse. But let me first kind of back up, talk about how these trusts get set up. Typically, they get set up in one of two ways. One way is to do it in your will. Your will has language that says something like, when I die, I leave my estate in trust for my spouse. I name so-and-so as the trustee, more on that in a minute. And perhaps it says that any income that the trust generates will be payable to my spouse for the rest of my spouse's lifetime. It will likely have provisions that say, under some circumstances, the trustee, which we'll get to in a minute, can make distributions to my spouse after I die for my spouse's health, education, maintenance, and support. That's the common HIMSS standard. And then the trust says that when my spouse later passes away, all those trust assets will revert back to, and you name your beneficiaries. It might be your children, grandchildren, might be others, but that's the aspect of, or that's the benefit of leaving it in trust for your spouse, is you get to control where those assets go when your spouse dies. They don't go to your spouse's heirs or your spouse's next spouse or whatever might be the case. So that's one way the trust gets set up, is through your will. The other way that trust gets set up is through if you have a revocable living trust. You may have a revocable living trust, and in that trust it would say, when I pass away, my trust will remain in place for the benefit of my surviving spouse. And again, you'll name a successor trustee to administer that. Spouse perhaps gets the trust income, perhaps for the rest of the spouse's lifetime, and you might provide that the trustee can make distributions to your spouse pursuant to that HIMSS standard that I spoke about a moment ago. So that's how trust for your spouses gets set up. Now let's talk about that important decision of who you should select as the trustee of that trust for your spouse to handle things after you pass away. So I'm going to give you four options. One option, probably the most common, is where you designate your spouse as the trustee of that trust. And you would do that if you, quite frankly, trust your spouse's judgment. Now, depending upon the trust terms, it's likely that in the trust instrument will give or allow your spouse the discretion to make distributions to themselves or to your spouse for your spouse's health, education, maintenance, and support. And so you perhaps would name your spouse as that trustee if you're confident that they won't abuse this discretion. Now, hopefully you have the kind of relationship with your spouse where you do trust your spouse's judgment, and that you know your spouse won't abuse that discretion that you're giving them by giving them that discretion to make distributions, quite frankly, to themselves. So the potential or the downside of naming your spouse as the trustee of this spousal trust is your spouse or the trustee has a duty to administer a trust impartially based on what is fair and reasonable to all of the trust beneficiaries, not only to your spouse, but they have to have that duty of loyalty to the people who are entitled to receive the trust assets after you and your spouse pass away. So one risk of naming your spouse as the trustee is they may take actions as the trustee based on what is in their best interest rather than what is in the best interest of those principal beneficiaries who would be entitled to receive assets when that surviving spouse passes away. And one of the biggest abuses that we see when a spouse is the trustee of a trust that's set up for themselves is is they do make distributions to themselves that are outside of what is reasonable pursuant to that HIMSS standard. Let's say they're trying to get that your spouse would be trying to get as much out of that trust because your spouse wants to direct where those assets go when spouse passes away versus leaving things in the trust to be received by your beneficiaries when your spouse passes away. So spouse might or might not be the right decision for trustee of your trust you set up for your spouse. Now, if you do name your spouse as the trustee, you want to make darn sure that you also provide for another successor or backup trustee, because that person is going to have a role. That person will have a role, that backup trustee to your spouse. They'll have a role when your spouse later passes away, because that's likely when distributions will need to be made to your principal beneficiaries, and your spouse won't be around. They'll have passed away, so you'll need a backup to your spouse under those circumstances. Option number 2 for who should be the trustee of a spouse that you leave behind of a trust that you leave behind for your spouse is someone other than your spouse. Often, dad, for example, might name one of his children as the beneficiary to handle that trust after dad passes away. And so the child is the trustee, one of the adult children is the trustee, and really same issue there, same potential problem regarding that duty of loyalty to all beneficiaries. If a principal beneficiary, someone other than the spouse, is the trustee of that trust left for a spouse, they might overly restrict the distributions that otherwise would go to that surviving spouse pursuant to that HIMSS standard. So a third option is to have a co-trustee arrangement. We don't see this too much, but in the right circumstances, it may work. Sometimes a husband, for example, might say, you know what, I want to leave my estate in trust for my spouse, and then when my spouse dies, I want to make sure it goes back to my kids. And that husband might say, I'm going to name my wife or my spouse, and I'm going to name one of my children as co-trustees to handle that trust together after I pass away for the benefit of my spouse, and then back to my kids when my spouse dies. So that could work, really it'll work. It's all based on the relationship that the spouse and the principal beneficiary, those co-trustees, it's all based on the relationship that they have. So you just have to look at the relationships and see whether you think that would work as a co-trustee arrangement. And then a fourth option for a trustee of a trust that you set up for your spouse, and we don't see this much because for some reasons I'll explain, is a corporate trustee arrangement. So you don't see this too much because traditionally it's been an option for the larger or higher net worth trusts that can afford to pay those traditional corporate trustee fees. But quite frankly, a corporate trustee, which could be a trust company or a bank that has a trust company and offers trustee services, the benefit is that corporate trustee can be objective. They don't have a dog in the hunt, as they say. They're just doing their job and being objective. That corporate trustee is likely going to have a good understanding of the legal, financial, and tax concepts of serving as a trustee. And then that corporate trustee would be compensated for their services out of the trust assets. So there's your 4 options. It's an important decision. I'd say most people wind up with that default, name their spouse as the trustee, but there's pros and cons of that. So I wanted to give you a few other options as well. Make sure you help me out by hitting the old like button there. We'll see you next time.